I want to talk about today a few matters concerning divorce and bankruptcy, and most importantly, child support matters and alimony issues. Anytime that you're filing a bankruptcy, the other spouse, if not included in the bankruptcy, can proceed with a divorce action. The other spouse can, even though there is a bankruptcy automatic stay in place, it does not apply to the establishment of child support or alimony. The other spouse can ask a state court to order that alimony be paid or child support be paid. Any current child support payments must be paid. Any current alimony payments must be paid. If they're not paid, in a Chapter 13 case, the court will seek an immediate dismissal of the case. Alimony and child support are totally protected claims under the bankruptcy code. Also, if you are divorced and you agree to pay for your other spouse's debt, such as on a credit card or a medical bill, and you do not pay that, and your agreement specifically says you will hold your spouse harmless, that debt owed to your spouse is not dischargeable under Chapter 7. For example, if you and your spouse owed Sears $1,000 during your marriage, and you had agreed to take the debt owed to Sears, and you filed bankruptcy, Sears can continue to collect, not from you because they are stayed or that debt will be discharged, but they can collect from the other spouse. Your other spouse has a right to take you, the bankrupt debtor, and file a contempt action in state court, which could result in a criminal contempt citation. It's very important that you pay marital support obligations and marital debt obligations, even though you have filed a bankruptcy. Also, if you were to file a Chapter 7 bankruptcy and a trustee recovers some assets, for example, if you have a timeshare that a trustee can sell, or a vacant lot in another state or even in this state that a trustee sells, and you do owe back child support, the good news is that that back child support creditor will get paid out of those proceeds before any other creditor gets paid. When the law was changed in 2005, child support became a first priority creditor. Child support and alimony are highly protected claims in bankruptcy, in summary. And therefore, when you file bankruptcy, you don't need to go in with the intention of discharging and getting rid of any of those debts. Really, the only thing you can do is that if you owe back child support and that amount has been established, you could possibly pay it over 5 years in a Chapter 13. What we find, however, is that most of the time that our clients will owe back child support, there's already a payment plan in place that is actually easier to pay than being in a Chapter 13. For example, the money's coming out of your check, or you agree to pay a smaller amount than you would have to pay in a Chapter 13. Numerically, for example, if you owe $12,000 in back child support, in a Chapter 13 you'll have to pay that at $200 plus a month. If you have an agreement whereby you pay your ex-spouse or the parent of the child $25 per week or $100 per month, you're actually better off not using Chapter 13 to adjust that agreement. Thank you.